Sun Alliance Insurance and others, and Textainer Group Holdings and others.
Yes. My lords and my lady, I appear on behalf of the appellants, the insurers, and my learned friend, Mr. Christopher Smith, KC, appears on behalf of the respondents, who I refer to as Textainer. This is an appeal from a decision of Mr. David Railton, KC, sitting as the Deputy Judge of the High Court. Just in terms of housekeeping before I commence my submissions, there are essentially three bundles, which are quite insubstantial in one sense. There's a core bundle, a supplementary bundle, and an authorities bundle. I don't know if my lords and my lady will be referring to the bundles electronically, in hard copy, or both.
I think we've all got hard copy.
The reason I mention it is if reference is going to be made to the electronic copy, the PDF is slightly out of kilter with the paginated numbers, but I can help you with that.
Unfortunately, that does tend to happen, yes. It's irritating, but
it's probably my fault. So,
well, not necessarily. It's a very common problem. So don't worry about it. But as I say, I think we're going to be using hard copy.
Very good. Thank you very much. And I also understand the estimate for the duration of the hearing is at 1.5 days. I think that's in accord with.
Well, that sounds more sensible than the original estimate we received of 2 days, which did seem unnecessarily long.
I think 1.5 days will be plenty of time. It may go short than that, but I suspect we'll creep into it tomorrow anyway. So
Yes, well, that's not a problem.
Now, there are three issues for consideration by the court, and they're summarised at my skeleton argument of paragraph 35, which you'll see in the core bundle tab 3, page 30.
Yeah.
And I think my learned friend is engaged on each of those issues, and Lord Justice Males, when gave permission to appeal, also referred to those three issues, and they're a distillation of the grounds of appeal. There is also a respondent's notice by Textainer in relation to the third issue, which I'll address when I come to it. Now, essentially, if I've got this right, and I'm sure I have, if I succeed on issues 1 and 2, the appeal succeeds. Alternatively, if I succeed on issues 2 and 3, the appeal succeeds. So issue 3 is an alternative to issue 1. But I don't think there are any other permutations which allow me to succeed. That's it. Now, before I actually launch into the substantive submissions, I think what I'd like to do, if you don't mind, is just to explore the background by reference to the losses which took place, the policies, the insurance payout, and the settlement agreement. It won't take long, but I think it's worth the exercise.
All right.
As far as the losses are concerned, Textainer suffered losses in respect of over 113,000 individual containers, which had been leased to Hanjin Shipping Company Limited. The losses had risen by reason of Hanjin's application to the Seoul Central District Court for an order of receivership on the 31st of August 2016. And on the 16th of February 2017, Hanjin was adjudicated as bankrupt. Now, the losses were of several types. They were either losses in the sense of the total loss of individual containers. That is where the containers are not recovered. Or they are costs incurred relating to the recovery of the container. Or there were costs incurred for the repair of the container if they were damaged. And there were also loss of earnings claims. And it may be, for example, one container generated different types of loss. Now, in broad terms, there were two different types of containers in the sense of the commercial basis on which they were leased to Hanjin. There were operating lease containers, which were just where it was envisaged that the containers would be returned at the end of the lease. And there were finance lease containers, and they were leased on the basis that Hanjin, as a lessee, would acquire title, or is at least entitled to acquire title to the containers upon full payment of all sums due under the leases. And now, as found by the judge below, the losses totaled approximately $101 million altogether. So they're the losses. The policies. If one could go back to page 26 in my skeleton argument, which is Cord tab 3, page 26. There's a table setting out the excess of loss insurance program. And you can see there's an uninsured retention of $5 million. And that any losses, therefore, which fall within that layer are borne by Textainer. And then there are 6 policies, insured layers, the primary, and then 5 excess layers. And you can see the figures set out there, and they're insured by different insurers. My clients, the appellants in this appeal, are the insurers under the primary and the first, second, and third excess policies. The 4th excess and the 5th excess policies are entered into settlement agreements, which also touched on issues of subrogation, and therefore they're not a party to these proceedings. And of course, above the excess of loss tower, which is losses in excess of $85 million, it's an uninsured layer, and therefore any losses which fall above that would be borne by Textainer. Now, the policy itself, we have the primary policy in the bundle. The excess policies just incorporate the terms of the primary policy, and that can be seen in the core bundle at tab 13. Page 164. This is the policy schedule, and you can see reference to the assured Textainer. There's the total sum insured is $5 million in excess of the retention, and then there's an annual aggregate limit for single lessees and an annual aggregate limit generally. And the assured's retention is identified as $5 million for all other claims, not off-hire equipment and general average and salvage. And if we go to the next page, this is the insuring clause under section 1, which covers physical damage and equipment recovery. And the first 3 lines set out the insuring provision. The insurers will indemnify the assured to the extent provided by this policy if equipment, i.e. the containers, is lost, destroyed, or damaged whilst being moved, delivered, or repositioned, or whilst located in depots or otherwise in store anywhere in the world during the period of insurance. So essentially, this is a classic property insurance, which covers loss of or damage to the property. And on the next page, you'll see a basis of valuation and indemnities provision. The basis of valuation of the equipment for claims and declaration purposes is for equipment firstly owned by the insured, which is the insured's depreciated book value. And then it goes on to say claims shall be payable at reasonable cost of repair or replacement, but not exceeding the lesser of the basis of valuation as defined above, or the market value of affected equipment, including all freight and similar charges. So what this essentially does is give a valuation for the property, but also identifies a limit in relation to the cost of repair. Then on the next page, we have extensions, page 167. And I won't read these out. I will come back to them during the course of my submissions. But you can see under extensions applicable to on-hire equipment, it provides, in respect of on-hire equipment, the insurers will indemnify the assured provided by this policy for, and then we have essentially 5 different types of costs or payments which are referred to, and each of them attract their own provisions and conditions. But they include the costs of recovery of containers, the costs of repair, and other charges. And of course, at the end, after the 5 categories of costs are referred to, it says caused by or arising from the failure of any lessee to fulfill their obligations to the assured with respect to such equipment. And then there's an including provision, which I'll come back to later. And then there's at the very bottom of the page, you can see there's provided that the maximum liability of the insurers under this subsection shall be the insured value of the equipment, and we've referred to the basis of value provision, the subject of the claim in accordance with the basis of valuation contained herein. And then page 168, we have section 2, which covers loss of earnings. And it provides that insurers will indemnify the assured for uncollected rental and other charges as specified in the lease or conditional sale agreement, which relate specifically to leased equipment which has not been returned, and just B, are not received as a direct result of such lessee's contractual default, bankruptcy, going out of business, or incurred by the insured. And there are 3 provisos, and I think the third proviso refers to the maximum liability of the insurers under this section shall be the lesser of 183 days equivalent charges per unit of equipment subsequent to the date of occurrence or any other limit specified herein. And at page 169, we have general conditions, and I think the only one which is, we need to concentrate on is reference to the Marine Insurance Act in the middle of the page, which provides that although not every section of this policy may relate to a marine adventure, all the terms, conditions, and warranties of the Marine Insurance Act of 1906 shall apply to the insurance under this policy. And then there's an English law governing law provision on the same page. And then, page 173, there are general definitions, and these are important because they were referred to by the learned judge below. And the first is annual aggregate limit, the maximum amount the insurers will pay for any claim or series of claims occurring or with dates of occurrence during any one annual period of insurance. And again, you have an annual aggregate limit for single lessees. And then the definition of claim is the aggregate of all losses and damages, including all costs and expenses suffered by the insured, resulting from each occurrence insured hereunder. And then we have a definition of date of final claim, the date exactly 12 calendar months after the date of occurrence, or as otherwise may be agreed between the insurers and the assured. And then the date of occurrence, the date and event which may give rise to a claim recoverable hereunder being the first of the following to occur. And item 1 is the date a lessee or depot has filed against it an involuntary petition in bankruptcy or similar type of involuntary proceeding. And 2, the date a lessee or depot admits in writing that it's unable to repay its debts or fulfill its contractual obligations. And then the definition of a date of preliminary claim, a date not later than 6 months after the date of occurrence, when the assured, having submitted written claims to the lessee or their legal representative, remains unable to recover equipment and or amounts due from the lessee in respect of the period after the date of occurrence. Now, as the judge noted below, even though the terms date of final claim and date of preliminary claim are defined, they're not used elsewhere in the policy. But the date of occurrence is, and claim as well. And on the next page, you'll see the definition of occurrence is page 174. Any one occurrence or all occurrences of a series consequent on or attributable to one source or original cause. So it's essentially originating cause. And then at page 176, there's a subrogation and mitigation provision, which I don't think bears on the issues, but it's just, I just draw it to your attention. And then claims conditions, page 177. Following the payment of a claim under this policy and in the absence of an indemnity from any other policy specified herein, any sums recovered from any other source whatsoever as or towards payment of the amount indemnified shall be shared between the insurers and the assured as follows. And then there's a distribution referred to. Now, my submission will be that this provision doesn't actually alter in any material sense the law of subrogation, so it's in accordance with what the law of subrogation provides. In any relevant sense in this, for the purposes of this appeal. There were arguments below as to the effect of this provision in other respects, but they're not pursued at this stage, or any more, I should say. So they're the provisions under the policies, and I'll come back to certain of them as necessary. So they're the policies. Now, as far as the insurance payout is concerned, during the course of 2017 and 2018, the insurers, under the various layers, paid a total of $75.1 million. This is of the $101 million claim. and that they were paid in respect of losses due or indemnifiable under the policies. So this represented a full indemnity under each of the policies except for the fifth excess layer, of which it was paid, of which 25.1 million was paid out of a limit of 30 million. So we then come to the recoveries, which is obviously gives rise to the issues in this particular appeal. In May 2019, at the invitation of Hanjin's bankruptcy trustee, Textainer presented a claim against Hanjin. Now that can be seen in the supplementary bundle at tab 2. This is the claim which was presented by Textainer in response to the invitation. It's actually not dated, so the assumption has been given that the request was made, or the invitation was made on the 16th of May 2019, but I don't think anything turns on the date.
Can I just ask?
Yes.
Will there be a transcript of today's?
I don't know. I don't believe so.
Thank you.
As requested by the letter issued by you dated 16th of May, we, Textainer, hereby claim that Hanjin owes rental costs, recovery costs, and total loss to us, which accrued as of the rehabilitation date of 1st September 2016 till 16th February 2017, amounting to $64 million approximately for containers under operating leases and $52 million approximately for containers under finance leases, for a total of $117 million approximately. All details and breakdowns of the above claims, please refer to the attached sheet. We hereby demand your prompt payment. And you can see on the next page the sheet which is attached to the letter. And there are two tables. The first one relates to operating leases, and the second one relates to finance leases. And you can see the totals in the bottom right-hand corner of each table. And then the figures are broken down by reference to rental fees, recovery costs, and unrecovered containers book value. They're the total losses. And I'll come back to this document, so I won't address it now unless you wish me to, but it's going to be relevant to my submissions later. So that's the claim. And then that led to a settlement agreement, which took place in October of the same year, which you can see at tab 3 of the same bundle, page 7. So the lessor is described as Textainer equipment, lessee, and I should make it clear that's only one of the defendants, but we're treating all the Textainer is being treated as en bloc for this purpose. And I don't think, again, anything turns on identifying which particular defendant is involved. So the settlement agreement provides the bankruptcy trustee hereby acknowledges and agrees that 25.886 million is the final estate claim amount, which is 40% of the total estate claim amount that the lessee claimed in the table below. And what you can see in the table below are the figures which correlate to the operating lease table at page 6 of the same bundle. So essentially what is being settled is the claim in relation to operating leases, not finance lease containers. And in paragraph 2, the lessor had processed the containers not recovered by the lessee as at the date of the adjudication of bankruptcy as total loss, and the bankruptcy trustee acknowledged the corresponding remaining amount as estate claims. Therefore, the lessor agrees that in case any additional containers which are subject to be disposed of as total loss are found after the settlement agreement date, the bankruptcy trustee shall have the full right and power to dispose such containers. And it require the approval of the sole bankruptcy court. So essentially, of the $117 million claim presented, only the operating lease container claim was settled. So there was no provision made in relation to finance lease containers. And of that claim, 40% was paid by Hanjin's bankruptcy trustee bankruptcy.
It may not matter, but do you understand why only the operating leases were addressed?
I don't. But then again, I'm not acting for Textainer, so I wasn't behind. So there may be a good reason, there may be a commercial reason, but it's not something I can answer in answer to my Lord's questions.
Thank you.
Now, in November, December of the same year, so this settlement was in October, Textainer received 2 payments in the total sum of $14.7 million approximately from Hanjin, and there may well be further payments to be made. So I think everything which I've mentioned to you by way of background in relation to the losses, the policy structure, the policy terms, the insurance payout and the recoveries, they're not in issue between the parties. And indeed, they're recorded in the Mr. Railton Casey's judgment below. So we come then to the issues on appeal. And essentially, it boils down to whether or not my clients, the appellants, are entitled to a 39.3% share of the monies received by way of payment by Hanjin pursuant to the settlement agreement. And that 39.3% represents the values or limits, if you like, of the primary policy and the first, second, and third excess policy, which is in total $40 million, as a proportion of the total loss of $101 million. So that gives you 39.3%. Again, that's reflected in the learned judge's judgment below. Now, it's the appellant's case that they're entitled to that 39.3% share of the recoveries pursuant to the law of subrogation and or the recoveries condition, which we say is to the same effect. Textainer denies that there is any such entitlement, and of course the judge also dismissed any claim for an entitlement on the part of my clients. And the dispute boils down to 3 issues which are referred to at paragraph 35 of my skeleton. And in shorthand, the first issue is whether the top-down approach, which was adopted by the House of Lords in Napier and Hunter, which I'll come back to, is applicable in this case. And the second issue was whether the judge was wrong to find that it could not be inferred that the operating lease containers and the finance lease container losses were suffered evenly and regularly over a period of time. And I'll explain the significance of that when I come back to it. And the third is, if I'm wrong about the top-down approach being applicable to this type of policy, whether there's a distinction to be made on the basis that this is a marine insurance policy where the principle of averaging applies, which is reflected in Section 81 of the Marine Insurance Act, albeit I accept that Section 81 is a coded reference in one sense, but it's been accepted by the courts on a number of occasions as reflecting the principle of averaging. And that principle of averaging does not apply outside the realm of marine insurance unless there's a provision in the policy to that effect. So what I propose to do in the conventional way is address each of the issues in turn. So issue 1, not surprisingly, will be first. And the judge has touched on this issue in a number of places, but I think the key aspects of his decision reflect in paragraphs 83 to 86 of his judgment. And essentially what the judge held was that the top-down approach laid down by the House of Lords and Napier Hunter was applicable to the losses insured and indemnified under these policies, and that there was no material difference between the nature of the losses in this particular case and the nature of the loss which was insured in the case before the House of Lords in Napier and Hunter. Therefore, there was no valid basis of distinction between the 2 cases. But Mr. Railton Casey also relied upon and referred to what he described as the aggregate limit provisions or the aggregation provisions, which I say are irrelevant to the analysis which has to be applied in this case. And then finally, the learned judge referred to the decision of Mr. Justice Langley in Q8 Airways against Q8 Insurance, and he says there was no meaningful distinction to be applied to that case. And my position on that is there is a material distinction, but if I'm wrong about that, then Mr. Justice Langley's decision in that particular case must be wrong. Now, I say, and obviously this is my appeal, therefore the judge was wrong in making the finding. The top-down approach is applicable, and therefore he should have found that it was inapplicable, because essentially for the following reasons, which I will develop. The first is that the policy in Napier and Hunter provided a single date for the determination's calculation of a single indemnifiable loss. It was made up of a multiple of credits and debits, I accept, but in order to determine whether there was a loss, the loss was considered at a particular point of time. By contrast, in this particular case, there were over 100,000 containers which were leased to Hanjin and 113,000 different losses. Each individual container loss, however described, whether it's total loss or the incurring of a cost, will give rise to an independent right of indemnity under the policy. And that right of indemnity occurs at the date of the loss. So, of course, because each loss is sustained at different dates, that gives rise to multiple rights of indemnity. The losses, as they occur, erode each other. Sorry, I beg your pardon, let me put that again. The losses as they occur erode the limits, firstly of the retention, then the primary policy, then the first excess policy, and so on until you get to the top of the tower. And therefore, any recovery which is obtained from the wrongdoer, in this case Hanjin, by virtue of the settlement, is to be applied to each indemnified loss to which the recovery relates. It doesn't apply indiscriminately to any loss, whether insured or uninsured. And finally, the judge was wrong insofar as he was influenced by the provisions relating to the aggregate limit. We say that has nothing to do with the date on which the loss becomes indemnifiable. It's only to do with the limits set on how much can be recovered. So these reasons why I say the judge is wrong actually embrace important concepts. The first one is, when does a right to an insurance indemnity arise in the case of a property loss? Secondly, how do multiple losses erode cover under a program such as this, which is subject to various limits? Thirdly, how are recoveries to be distributed having regard to the principle of indemnity and the law of subrogation? And then finally, the role of the aggregate limits. What part do they have to play in this whole process? So if the court is happy, I propose just to touch on the general principle of subrogation. And again, forgive me if this is well known to you, but it's a fundamental principle of the principle of indemnity, and applies not just to insurance indemnity contracts, but to all indemnity contracts. And what is clear is when an insurer pays a loss by way of an indemnity, an indemnity essentially is compensation for the loss which has been sustained by the insured. Whatever is subsequently received by the insured, which diminishes the loss indemnified by the insurer, belongs to the insurer. So very simply, if the insurer has paid $100 indemnity to the insured in relation to damaged container, and then the insured sues the wrongdoer who was responsible for the damage and recovers $50, that $50 then belongs to the insurer. And that too avoids over-indemnification, over-compensation by the insured, and it also ensures that the amounts paid out by the insurer are reduced to reflect the insured's actual loss. Now, this principle is set out firstly in Section 79 of the Marine Insurance Act, which applies because these are marine risks, but also because the contract provides for the Marine Insurance Act to apply in all circumstances. And it's at tab 16 of the authority manual. Page 247. I think the number is at the top right-hand corner. So under the heading right of subrogation, subparagraph 1 is concerned with total losses, and subparagraph 2 is concerned with partial losses, which is basically any loss which is not a total loss. Where the insured pays for a total loss, either the whole or in the case of goods of any apportionable part of the subject matter insured, he thereupon becomes entitled to take over the interest of the insured in whatever may remain of the subject matter so paid for. So that's the right of salvage. And he is thereby subrogated to all the rights and remedies of the insured in and respect of this subject matter as from the time of the casualty causing the loss. And then subparagraph 2 is in very similar terms, except it doesn't provide for acquiring title to the subject matter. So where the insurer pays for partial loss, he acquires no title to the subject matter insured or such part of it as may remain, but he is thereupon subrogated to all rights and remedies of the assured in and respect of the subject matter insured as from the time of the casualty causing the loss, insofar as the assured has been indemnified according to this act by such payment for the loss. Now, we're not concerned with the right to salvage. There's not any issue here about the insurers taking over title to the insured property in the case of a total loss. We're only concerned with the general principle of subrogation. And that's helpfully explained by the editors of McGillivray, which is at tab 14 of the same bundle. Page 228. And I can pick it up halfway through paragraph 22-001. In insurance law, subrogation is the name given to the right of the insurer who has paid a loss to be put in the place of the insured so that he can take advantage of any means available to the insured to extinguish or diminish the loss for which the insurer has indemnified the insured. It is an instance of the fundamental principle of indemnity insurance that the insured shall receive no more than a full indemnity for his real loss and must not be permitted to make a profit out of being insured. And then this next paragraph, the editors state that the doctrine confers two distinct rights on the insurer after payment of a loss. The first is to receive the benefit of all rights and remedies of the insured against third parties, which if satisfied will extinguish or diminish the ultimate loss sustained. The insurer is thus entitled to exercise in the name of the insured whatever rights of the insured possesses to seek compensation for the loss from third parties. This right is a corollary of two fundamental principles, which I don't need to address. But we can get on to paragraph 22.05, which is on the next page. So we're skipping some text. It says the second right vested in the insurer by the doctrine of subrogation is to claim from the insured any benefit conferred on the insured by third parties with the aim of compensating the insured for the loss in respect of which the insured has indemnified him. The right is usually exercised by an insurer claiming from the insured a sum equivalent to any sum of damages paid to the insured by a third party legally liable for the claim. And the right is wider in scope than that, however, and the insurer is entitled to monies paid to the insured ex gratia to diminish his loss unless intended by the donor to benefit the insured to the exclusion of the insurers. So there are two rights, essentially. One is to be allowed to exercise the name of the insured, rights of actions against third parties. But once those rights of actions, or any rights of actions which are crystallized in the payment of compensation, is received by the insured, then the insurer can then take over those funds. And to the point that the House of Lords in Napier and Hunter has actually held that the insurer acquires an equitable proprietary interest by virtue of a lien over the funds which are received by the insured. So the key point here is, as stated by the editors of McGillivray, is that the right of subrogation attaches to any recoveries which are paid in respect of the indemnified loss. Now, the recoveries condition, which I referred to in the core bundle, and I don't need to go to it again, it's tab 13, page 177 for your reference, adopts the same solution because it says, following the payment of the claim, any sums recovered from any other source whatsoever, as or towards payment of the amount indemnified, shall be shared accordingly. And of course, because these insurers, under the primary, first, second, and third excess policies, have paid a full indemnity, there's no sharing because all those losses have been indemnified by the insurers, and therefore any recoveries which are attributable to those layers therefore belong to the insurers by way of subrogation. Now, as a matter of law, things get complicated in a number of different ways. And for example, if this were a single loss, of a ship or a building, and there was damage, and the insurers only paid out, for example, 50% by way of a compromise, and the insured recovered 40% of the loss from a third party, then there's no right of subrogation until the until the insured is fully indemnified for the loss it's sustained. By contrast, if the insurer had paid out 50% and the insured had recovered 70% from a third party, then 20% would belong to the insurer, the rest would remain with the insured. But there are exceptions to that, which I don't need to go into because they're not relevant to these purposes. But this is not a case where there's a single loss, for example, by reference to a single ship or a single building. This is a case where we are concerned with multiple losses, indeed potentially over 100,000 different losses of different types, whether they're total losses, costs of recovery, or loss of rental income. And therefore, we therefore have to consider, firstly, two things. When does a right of indemnity arise in relation to those myriad losses? And secondly, how do those losses erode the limits? How do we know to which policy or uninsured layer each loss belongs? Now, the first one is quite easy because it's well established as a matter of law that the right to an indemnity arises when the loss occurs. And this is made good in a recent decision of the Commercial Court in a case called Griffiths and Liberty, which you can see at the authorities bundle, tab 13. I beg pardon, it's not the Commercial Court, it's the Technology and Construction Court. And it's paragraph 14 of the judgment at page 223. And his Honour Judge Pelling QC, as he was, basically set out the principles as a matter of law. I don't need to look at the facts. And adopted what was stated by Sir Peter Webster in an earlier case, which is in the bundle if you need to look at it, Callahan against Dominion Insurance. Paragraph 14 on the right-hand side, page 223, the learned judge says, it is common ground the policy is an insurance policy. The defendant maintains that it is a policy of indemnity insurance. By the time of the hearing, it was common ground that this was so. The claimant submits, therefore, that in the absence of clear words to contrary effect, liability, that's the insurer's liability, arises immediately and insured loss is suffered as a result of the happening of an insured event. See Callahan against Dominion at page 544, where Sir Peter Webster stated, under such a policy, there is a primary liability, that's to say to indemnify, and a secondary liability, that's to say to put the insured in his pre-loss position, either by paying him a specific amount or it may be in some other manner. The fact that an insurer has an option as to the way in which he will put the insured into his pre-loss position does not mean that he is not liable to indemnify in one way or another immediately that the loss occurs. In the result, Sir Peter held that the indemnity insurance policy being considered by him was an agreement under which an insurer conferred a contractual right on the insured, which came into effect for limitation purposes immediately a loss was suffered, caused by the event insured against, and the cause of action accrued for limitation purposes on the date that the loss occurred, not the subsequent date when the insurer avoided the policy. This principle has been consistently followed and applied in the following cases. The outcome is likely to be different only if the express terms of the policy provide that an indemnity is not payable until a date after the date of loss or can only arise after the date of the loss. Now, what also, Sir Peter Webster also said is even if the loss is not quantifiable at the date of the loss, so for example, just imagine a ship sank and it was unclear how, or the ship was severely damaged and it was unclear how much it would cost to repair the vessel. The mere fact one couldn't quantify the loss at that date, because it would take obtaining quotes and tenders, etc. It did not detract from the fact that the right to sue for an indemnity under the policy occurred immediately when the damage occurred and the loss occurred. So that's fairly orthodox as a principle. So in indemnity insurance, essentially it's regarded as a promise by the insurer to hold the insured harmless, so that once the loss occurs, the insurer has not complied with its promise. This is the traditional way of looking at it. And the cause of action, for limitation purposes, but all purposes, arises at that date. Now the question then arises, we have over 100,000 losses on my submissions in this particular case. All of a different type: total losses, cost of recovery, cost of repair, loss of rent, loss of earnings. They all are suffered at different times in different circumstances. They may occur on the same day, but they may not. And the right to indemnity in relation to each one of those accrues at the date the loss is suffered. So when you have so many losses which are occurring, how do we know to which policy or to which uninsured layer the loss is to be treated? So if it's the very first loss which occurs, we know that it must be borne by the insured because the insured has a $5 million retention. And it's only when $5 million worth of losses occurs that it then the primary policy begins to respond.
Can I just clarify one thing?
Yes.
As I've understood from the judgment and the skeletons, the period we're concerned with is the 1st of October 15 to the 30th of September 16.
That's the date of insolvency, of the filing of the bankruptcy, I should say, petition with the sole court. 31st, did you say, my lord, did you say 31st of August 2016?
No, I thought that the policies we were concerned with covered the 1st of October 15 to the 30th of September 16.
Yes.
But the policy we have got at tab 13 seems to cover the
It does.
previous year.
I have to admit, when I was reading through the policy, I saw that. I wasn't going to trouble you, my lords and my lady, with it, but now that you've raised it, the parties have been treating this wording as the same wording as the 2000 and the next year's policy, even though it's got this particular policy has the period for the previous year, but that's not an issue between the parties.
Okay, so we have the wrong policy, but the right policy is in the same terms.
Exactly the same terms.
Why haven't we got the right policy?
That's a very good question, and I don't know the answer to that. Do I know the answer? It was all we know is this was a policy renewal on these terms, but this is not an issue between the parties.
No, I understand that.
So it's a very good question. I hope you understand why I didn't. I saw the point. I was going to raise it before, but I thought.
No, I understand. It's not an issue. I understand that. Can I just ask one other, just one other point while we're looking on the issue of the policies? The policies are described as lessee default policies. That's right, is it?
Yeah, because it's the lessee's default is the insured peril which gives rise to the indemnifiable loss.
So the provisions in section 1.
Yes.
Those risks are only triggered on the default of the lessee.
Well,
It seems to be on the wording.
Well, yes. As far as I mean, as a matter of fact, in this particular case, what has happened, of course, the lessee has become insolvent, and therefore the containers weren't being returned, and in the process, therefore, the insured had to incur costs to recover them. But if they weren't recovered, they were lost. But you're right to say that the unadulterated provision at page 165 of the bundle, which provides for an indemnity, it says to the extent provided by this policy, is in relation to lost, destroyed, or damaged equipment while being moved, delivered, or repositioned, or whilst located in depots or otherwise installed anywhere in the world. And I don't think it's troubled the parties before, but the question which I haven't considered is whether or not the relevant insured peril must be the default of the lessee as opposed to something else. So, for example, fire at a particular warehouse. But what I would say is the extension, which you see at page 167, is dependent on there being a failure of the lessee to fulfil their obligations under leases.
Yes, can you help me with this? It's described as an extension, but
Yes.
is that intended to be, as that word indicates, something that's additional to the physical
It is.
damage?
It is. Extensions on insurance policy, at least in my experience, traditionally are supplementary or add-on or bonus covers, if you like. They're not that you'll have a standalone cover, and then an extension will provide additional cover in addition to the standalone cover. For example, all the COVID business interruption cases which we've seen recently be before the courts. The standard cover is described as material damage and business interruption arising from the damage, but you'll have extensions which provide additional cover even if there's no damage. For example, if premises are inaccessible.
Okay. No, I understand that. The further question, though, is whether the various categories of loss that you've referred to are actually within the extension text or within the principle, the initial.
Well, if one looks at the extensions, all that's being recovered, all that's insured there are costs incurred, essentially. So what's not insured are the loss, for example, of the containers.
So a total lost container would not, you say, be within the extension?
No, it would be within the principal insuring provision. I hope that's answered my lady's question.
Yes, because as you indicate, both the extension language and obviously the loss of earnings language have references to the date of occurrence.
Yes, and I will explain what that means.
Thank you.
So don't think I'm not coming back to it, I am. So just to repeat, if there's a loss, an individual loss which is indemnifiable under the policy, that is the point at which the right to indemnity, the right to sue the insurer occurs, even if the amount of the loss is unknown or not yet quantified. That is the point of time. So when you have multiple losses, such as in this case, on my submission, each individual loss gives rise to an independent right of indemnity. But the question then arises, how do we know under which layer, whether it's uninsured or insured, that particular loss belongs? In other words, I think I said earlier, if it's the very, very first container loss which is suffered, we know that that will fall within the retention, but once those losses add up to $5 million, then you go into the primary policy. So any container losses which occur after that $5 million limit is hit, then is to be borne by the primary insurer, not the insured. And it goes on and on until you go through all the layers. And once you get to the top insured layer, which is $85 million, anything above that is uninsured and therefore has to be borne by the insured. So this principle, but how do we know which losses belong to which policy or which layer? And the answer is very simple, and it's not surprising. It's the chronological order in which the losses occur. And this point was made good by the Supreme Court in a case called Teal against Barclay, which is at tab 12 of the authorities bundle. And I think it's just worth referring to the head note at page 208, where the Supreme Court, I beg your pardon, the facts were that BV, Black and Beach, I hope I've got pronunciation right, was insured against professional indemnity liabilities above a self-insured retention of $10 million. The primary layer of $5 million was with Lexington, and that policy stated that BV would pay the deductible and self-insured retention. Above the Lexington policy was a professional indemnity tower consisting of 3 excess layers, and then those layers are set out, each with their own limits. You can see the limits set out. Just about 5 lines from the end of that paragraph, there was also a top and drop policy which applied in excess of the Lexington policy and the PI tower, and had a limit of £10 million or equivalent excess of the underlying retention of $10 million. And then you can see in the top right-hand, the second column, in the top right-hand corner, there's a provision, condition 3. I beg your pardon, I should look at the last paragraph in the left-hand corner. It says, there's the LSW 055 clauses apply. Condition 1 stated that liability to pay under this policy shall not attach unless and until the underwriters of the underlying policy shall have paid or omitted liability or have been held liable to pay the full amount of their indemnity, inclusive of costs and expenses. And then you have a provision, condition 3. If by reason of the payment of any claim or claims or legal costs and expenses by the underwriters of the underlying policies during the period of insurance, the amount of indemnity provided by such policies is partially reduced, then this policy shall apply in excess of the reduced amount. And then if it's totally exhausted, then this policy shall continue in force as the underlying policy. So that basically means if you've got a loss which depletes part of the cover on the underlying policy, the policy in relation to a new claim will come down and operate as the underlying policy, at least in part. So it's a drop-down provision. I don't think this is relevant for our purposes, but I do refer to it because my learned friend refers to one of the drop-down provisions in the policy in this case. So I don't think we need to go into the actual issues which arose, but there is a discussion by Lord Mance at paragraph 13, which is at page 213, where he refers to the nature of third-party liability insurance. Now, I'm not going to read out paragraph 13 because I don't need to, but it's important, I suppose, to bear in mind this consideration before I take you to the latter parts of Lord Mance's judgment. When it comes to indemnity insurance, basically splits into, forgive me for if this is something you're fully aware of, I'm sure you are, but indemnity insurance comes in 3 flavors, essentially. There's property insurance, financial loss insurance, and liability insurance. So property insurance is where property is lost or damaged, or there are other costs associated with the property. Financial loss insurance is basically loss of income, loss of profit, loss of revenue, or additional expenditure of certain types. And the third is third-party liability. This is where the insured incurs a liability to pay compensation to a third party. Now, the reason that's important is because, and one needs to understand it when one looks at this judgment. I indicated before that the cause of action, the date of an entitlement to sue the insurer for a loss under indemnity insurance occurs when the loss occurs. Now, for property and financial loss insurance, which is sometimes referred to as first-party loss, that occurs when the damage occurs or when the cost is incurred, so when money is outlaid. For liability insurance, as a matter of law, it's not when for example, the negligence which gives rise to the third-party claim arises. It's not even when the claim is made against the insured, but it's when judgment is entered against the insured or there's a settlement agreement, which is, and the phrase is, either establishes or ascertains that liability. Now, of course, in this particular case, we're not concerned with liability insurance. We're concerned with first-party loss insurance. But it is neat. I mention this when looking at because it's important to understand when looking at Lord Mance's judgment. I think, therefore, we can look at paragraph 16 on page 214. And I think the principle I've just referred to is set out, for example, in paragraph 15 of the judgment. But in paragraph 16, Lord Mance states, Mr. Christopher Butcher QC for Teal challenges the proposition that the ascertainment, which is the establishment of liability by judgment or settlement, of a claim against the insured exhausts the insured's insurance policy cover pro tanto. He accepts that under a claims-made liability policy like the present, an insurer's liability arises typically as and when loss within the scope of the policy is ascertained as against the insured. But he submits that it's only when the claim is met by the insurer that the policy cover is pro tanto exhausted. Until then, it is possible, if a second notified claim is made and ascertained against BV as the insured, to speak of a second cause of action or claim existing under the policy. BV is free to claim, and the insurer is liable to make payment of the later rather than the earlier ascertained claim. As regards expenses incurred by BV and covered under endorsement 8, he submits that BV as insured can again choose which expenses are paid first and against which claim or claims it sets the self-insured retention or deductible. And after the retention and deductible are used up in respect of which claim, it claims payment of such expenses from its insurer. In the last situation, it is again only when insurers pay those rather than earlier ascertained expenses that the cover can be said to be exhausted. I cannot accept Mr. Butcher-QC's case on these points. When an insurance has a limit, it makes no sense to speak of the insured having causes of action or recoverable claims which together would exceed the limit. If the limit is $10 million and the insured incurs ascertained third-party liability of $10 million in respect of each of his 2 successive third-party claims, it makes no sense to speak of the insured having 2 causes of action or 2 recoverable claims against the insurer totaling $20 million. Likewise, if its liability is ascertained at $7.5 million each claim, the insurer will have 2 causes of action or claims against the insurer, but the second will only be for $2.5 million because it's a $10 million limit. The ascertainment by agreement, judgment, or award of the insured's liability gives rise to the claim under the insurance, which exhausts the insurance either entirely or pro tanto. The claim against the insured must, of course, fall within the scope of the policy, and the insured may have to fulfill procedural requirements regarding notification. But this appeal raises no issue regarding such points. Then he goes on, Lord Matz goes on, similar considerations govern incurring of ascertained expenses, whereas here, these fall potentially within the policy indemnity. As and when BV incurs quantified expenses, they fall to be set up against the policy retention and deductible. Over and above the retention and deductible, any further expenses incurred fall not within the retention and deductible, but within the insurance provided by Lexington. So there he's talking about first party loss, the expenses incurred as opposed to liability. And then Lord Matz concludes, the policy thus serves the purpose of meeting each ascertained loss when and the order in which it occurs. The insured can forbear from notifying or can withdraw or abandon a claim under an insurance policy in respect of expenses or third-party liability. The insurance will not then be exhausted by that claim, and the next claim will be recoverable in the ordinary course under the insurance. But what is here proposed is not the withholding or withdrawal of a claim, it is its continued pursuit coupled with adjustment of its priority as against the insurance or program of insurances. So the point Lord Matz is making is that as and when one is dealing with liability, as and when the liability is ascertained by judgment, award, or settlement, that's when that particular loss erodes the limit. And it's done in the order in which that ascertainment takes place. And similarly for expenses, it's done in the order in which the expenses are incurred. So when that's significant in this particular case, because when one is considering how when you have so many losses, over 100,000 losses, which fall for indemnity under this, at least partially under this program of excess loss insurance, one needs to know that each individual loss is to be essentially attributable or allocated to a particular layer. And that allocation is done by reference to the chronological order in which the loss is incurred. So,
just pausing there,
of course.
It seems to follow from what you've submitted so far that in such a case it will be of crucial importance to insured and insurer to establish the precise chronology of every loss.
It's certainly of importance, absolutely. I agree, my lord.
Yeah. Thank you.
But that touches on my second issue, which I will address coming up, which is, can it be said or can it be inferred in these circumstances that the losses which were incurred and for which an indemnity was payable were incurred evenly and regularly over time, or were they all bunched up? For example, with the finance lease container losses occurring all on the
Well,
first.
we'll come to that issue when we come to it.
Yes.
But the reason I asked the question I did, and if it wasn't clear, let me now make it clear, is that if you're right on what you've been submitting so far, the logic would seem to suggest that there's no room for making assumptions, because the logic of your argument thus far seems to indicate that chronology is critical, and therefore a chronology must be established for each and every loss.
Well, the difficulty with that approach is this. I mean, and I will come back to it. It is critical, and I accept that. But what that doesn't answer is the question of how that chronology can be established. And the difficulty arises because just assume on this particular case, the insurers were exercising rights of subrogation by suing Hanjin directly, in the sense that they used the insured's name, but they were controlling the proceedings. And then the insurers recovered the $14 million or the $25 million from Hanjin. So the question then arises, if Textainer wanted to sue the insurers for their share or entirety of that recovery, they would face the same difficulty if there was a difficulty about establishing chronology without the use of an inference.
We'll come on to the question of inferences later. And I apologise because I'm diverting you from your immediate subject matter, and we must come back to this later. But what's puzzling me at the moment is that, as I say, it seems to me to be inherent in the logic of your argument that every time there's a loss, each insurer in the layer needs to know what the date of that loss is, because otherwise they don't know if they're liable or not.
Well, that is true if this was a slowly accruing series of losses. In this particular case, the indemnity was paid out by the insurers at a time when it was known that the losses were, in any event, however one characterized it, however one established the chronology, that the insurer's liability was going to be engaged. So it was the losses were so large. I mean, we can see within 6 months of the 31st of August 2016, the loss has been calculated at a very large sum, over $100 million. So that clearly, on any view, however one characterizes the chronology of losses, was going to engage the insurance cover. So the question, and of course, as far as the payment of an indemnity was concerned, it didn't matter when you have so many losses all falling within the scope of relevant cover, how the chronology is established. The chronology only becomes important subsequently when one is dealing with the treatment of recoveries. So in one sense, my lord is right, but given the sheer extent of the losses, it became academic. It didn't matter in which order the losses were incurred, because they were going to engage the entirety of the cover.
All right. So I've diverted you from where you were, so please resume.
I will. Thank you very much, my lord. So I've just touched on this notion how losses erode cover in a particular order, which is a chronological order in which the losses occur. The Hanjin settlement is, I've already taken my lords and my lady to it. It's a settlement agreement by which Hanjin has agreed to pay 40% of the operating lease container claims, but nothing towards the finance lease container claims. So in a sense, that's given rise to one of the difficulty rising on the second issue. Now, what the judge rightly accepted at paragraph 119 of his judgment was that the monies which were payable under the settlement were payable with respect to all operating lease container losses on a pro rata basis. And this is adopting the position adopted by the House of Lords in a 19th century case called Thompson and Hudson, which was a much simpler case. It was a settlement paid for 3 claims. And the settlement agreement didn't allocate the settlement to any one particular claim or any one particular debt. So the House of Lords held it was to the settlement, which wasn't for the full amount, was to be allocated to each of the three debts on a pro rata basis or a proportionate basis. And that's where, and the judge found that in this particular case. And we say, in essence, and as the judge accepted, the settlement agreement in Thompson and Hudson, which is the 19th century House of Lords decision, is in substance the same as the Handling settlement. Sorry, I don't mind Lord Justice Phillips is about to ask me a question.
No, thank you. I was just thinking about what you were saying.
So that leads me, with that, if you like, build up, I can then deal with the top-down principle and why it doesn't apply in this particular case. And the top-down principle is essentially set out in Napier and Hunter, which I've referred to a number of times, and it's tab 6 of the authorities bundle. And if I could ask you to turn to page 728, page 90.
Just before we get into the details of this case,
Yes.
can I ask you what may seem a very strange question?
Yes.
But there is a purpose to it, which is obviously this court is bound by the decision of the House of Lords in Napier. But can I ask you this question? Let's assume that Napier had not been decided, and we were free to decide for ourselves what the applicable principle should be. In that hypothetical circumstance, would you be here arguing that top-down was wrong in principle?
No,
Right.
at least in relation to non-marine insurance.
Okay.
And that gives rise to the third issue, if it arises.
Thank you.
No, I think, I have to say, I think makes perfect sense why it should apply in those particular cases. And the way I test it, and if you just take, for example, just a much simpler example, which is damage to a building or a ship. It's probably a bad example, actually. We'll just take it, yeah, say damage to a building or a ship. Well, I say a building because it's non-marine. It's damage to a building, and the building is insured for $20 million. But that's not the full value of the building. The building is actually worth $40 million. So it's, in a sense, it's underinsured. Now, the principle of averaging, which applies to marine insurance, doesn't apply to non-marine insurance. And that gives rise to different considerations. But if, for example, the insurers pay out $20 million of the $40 million loss, and then there's a recovery of $10 million from a third party, the question arises: who gets that $10 million? Is it the insurer who's paid out $20 million, or is it the uninsured? So the insured who's not insured for anything in excess of 20. And it seems to me it's plain it goes to the insured, because if that money had been received before the indemnity had been paid out, the loss would no longer have been 40, it would be 30, but the insurer would still have to be paid $20 million. So the receipt of the $10 million doesn't affect the insurer's liability at all. And that's what the House of Lords essentially was getting at.
So I think you have thereby accepted that the logic is that the situation shouldn't depend upon date of payment, i.e. whether it's before or after indemnification.
Well, it makes it does, when you're talking about multiple losses, it makes a difference, because for this reason, because just imagine there are two losses which occur, and the insurer pays out the first loss, but not the second. And the reason for that is the first loss has exhausted the limit of the policy. Now, if, however, the insured had recovered compensation for that first loss before the insurer paid out, then the insurer would no longer be liable to pay that first loss, because the loss has been extinguished. So then we would become liable for the second loss.
All
But
right. Well, this is a point you're going to be developing in a moment,
I will.
but it suggests to me a different answer to the question that I originally asked. Because I asked the question, if we were free from authority, would you argue that top-down was wrong on principle? And you said no, it's fine for non-marine insurance. But the answer you're giving me now is no, is yes. It's wrong in principle when it comes to multiple losses.
Yeah, but my point is, Napier and Hunter was correct because it was a single loss. That's the point. That's the basis of distinction between Napier and Hunter in this particular case.
That's a different distinction from marine versus non-marine.
It is, and that's an alternative case. But my first point is this, and that's why I say that Napier and Hunter doesn't apply and doesn't bind my lords and my lady in dealing with this particular issue, because
well, you're saying not merely is it not binding, but the principle is inapplicable.
Inapplicable because of the very nature of indemnity and subrogation.
Yeah. All right. So now we need to look at the case.
Yes. So forgive me for. I hope I've answered your question.
Yes, you have. Thank you.
So if we go to the top-down principle, it's tab 6. This is Napier and Hunter, page 91 of the authority bundle. Page 728. Lord Templeman begins by discussing what subrogation is all about when he says, "My lords, when an insured person suffers a loss, he will be entitled to the insurance money, and may also be entitled to sue for damage to anyone responsible for the loss. For example, if a house is insured for £100,000 against fire and is damaged by fire to an extent exceeding £100,000, the insurance company will pay £100,000. If the fire has been caused by a negligent builder or some other contractual or tortious wrongdoer, the insured person will sue the wrongdoer for damages. If the house has been damaged to the extent of £160,000, the insured person will receive damages from the wrongdoer of £160,000. At that stage, the insured person will have made a profit, since he will have suffered a loss of £160,000, but will have collected a total of £260,000 from the insurance company and the wrongdoer. A policy of insurance is, however, a contract of indemnity, and by the doctrine of subrogation, the insured person must pay back to the insurer the sum of £100,000. The insured person will then have made neither a loss nor a profit. This appeal requires consideration of the principles and application of the doctrine of subrogation. Now, I'll continue, if you don't mind. The persons insured are 246 members of the Althwaite Syndicate, the names. The wrongdoer was the managing agent of the syndicate, Althwaite, who negligently wrote large number of policies on behalf of the names in respect of asbestosis claims without adequate reinsurance cover. The insurers are the appellants, the stop-loss insurers. As members of the Althwaite Syndicate, the names were entitled to share the net premiums and personally liable to pay claims received under policies issued by Althwaite on their behalf in the year of account of 1982. The names were desirous of insuring themselves against part of any loss they might incur as members of the syndicate. Each name therefore paid a premium to the stop-loss insurers for a policy whereby the stop-loss insurers agreed to, quote, indemnify the insured for the amount by which the assured's overall ascertained net underwriting loss, as hereinafter defined for the underwriting year of account shown in the schedule, exceeds the amount stated as the excess in the schedule. And then the policy contained a definition of net underwriting loss in the following terms. The underwriter's liability hereunder shall not exceed the amount stated as limit in the schedule. Limit and excess shall apply separately to each underwriting year of account covered hereunder. The term overall and ascertained net underwriting loss shall mean such sums with which the assured shall be debited by any of his or her underwriting agents in respect of his or her underwriting results, being the disclosed loss as per the underwriting accounts as at the end of the 36th month of each separate underwriting year of account, less B, such sums as the assured shall be credited from any of his or her underwriting results as shown in the account at the end of the 36th month of each separate underwriting year of account. One of the underwriting years of account was 1982. The limit and the excess varied from policy to policy. And then Lord Templeman says, and this is the basis upon which the principles are discussed, on the illustration which Lord Templeman now gives. For the purposes of illustration, the arguments in the courts below and in this House assume that for the 1982 year of account, a particular hypothetical name suffered a net underwriting loss of £160,000, that the excess was £25,000 and the limit was £100,000. On these figures, the stop loss insurance paid to the name £100,000, being the fixed amount of the limit, £100,000, which exceeded the excess, £25,000. The names, together with the other names, sued Outhwaite for damages for negligence and breach of duty in respect of, inter alia, the 1982 year of account. Those proceedings were compromised on payment by Outhwaite of £116 million to the respondents, Richard Butler, as solicitors for the plaintiffs in the action. For the purpose of the illustration, it is assumed that, including the £116 million, Richard Butler hold £130,000 attributable to the overall ascertained net loss of £160,000 suffered by the hypothetical nature for the 1982 year of account. And then on these assumptions, two problems arise. First, how much is payable to the stop loss insurers by way of subrogation? And then second, are the stop loss insurers entitled to be paid the amounts found due to them by way of subrogation out of the damages now held by Richard Butler? So the second issue gave rise to the finding by the House of Lords that there was the insurers had an equitable proprietary interest in the funds received by Richard Butler. But that doesn't concern us. It's the first issue which is important. And the decision made by the House of Lords is reflected, I think, page 730, so the next page. And one can see Lord Templeman going through the process, and at the top of the page, he says, the problem must, in my opinion, be solved by assuming the name insured the first 25,000 of any loss, and also insure the excess over 125,000, as well as insuring the £100,000 payable under the policy with the stop loss insurers. So basically, there were then three insurance policies as follows: a policy for the payment of the first £25,000 of any loss, a policy for the payment of the next £100,000, and then a policy for the payment of the excess of £125,000. And when the name suffered a loss of £160,000, the name received £25,000 under the first policy, £100,000 under the second, and £35,000 under the third. The damages payable by Outhwaite were £130,000. The third insurer is entitled to be the first to be subrogated, because he only agreed to pay if the first two insurances did not cover the total loss. Accordingly, the third insurer must be paid £35,000. The second insurer is entitled to be the second to be subrogated, because he only agreed to pay if the first insurance cover proved insufficient. Accordingly, the second insurer must be paid £95,000, and the sum of £35,000 payable by way of subrogation to the third insurer, and the sum of £95,000 payable by way of subrogation to the second insurer exhausts the damages of £130,000 received from the name, by the name from Outhwaite. There is nothing left to recoup to the second insurer. The balance of £5,000 out of the £100,000 he paid under his policy. There is nothing left by way of subrogation for the first insurer in respect of the first £25,000, which he agreed to bear. And essentially, he then goes on to say, well, the principle should be no different if the first and the third layers were uninsured as opposed to insured. And so essentially what he's saying, what Lord Templeman's saying, as the other law lords agreed, is that if there is recovery in relation to this particular loss, it's to be fed top down, so that the topmost layer gets whatever recovery extinguishes that loss, that layer, then whatever remains goes to the next most layer, and so on until the recovery runs out. But the important thing to note about this case is that firstly, the House of Lords was using a very simple illustration, but the definition of the loss which is recoverable was what the net loss was at a particular point of time, which was at the end of the 36-month period of the year of account. Now that may be made up, I quite accept, by a multiple of debits and credits, but it's only the figure at the end of the 36-month which matters. So, for example, if there'd been a massive profit on the day before that key date of the end of the 36-month period, that would have completely changed the loss complexion, which was recoverable, perhaps not even recoverable at all, at the end of the 36-month period. So it's, even though it's made up of a series of losses and credits and debits, one is looking at calculating a loss in a particular way according to a formula used in the policy. And that's the basis of the illustration which was used by the House of Lords to determine this principle. What the House of Lords was not doing was considering a scenario such as the present, where there are over 100,000 separate individual losses occurring at separate times. And all considering how such individual losses may erode cover under such a program of insurance. So, obviously the issue which becomes important for these purposes is if the learned judge below is correct, then the $14 million recovery, or potentially more if more further payments are made, are to be applied top down. That means they fall within the uninsured layer in excess of $85 million. And I don't know if it helps to look at my table at paragraph 35 of my skeleton. Oh, sorry, the table of my skeleton, just to remind yourself of what how the program looks. It's tab 3, page 26. So, given that anything in, bearing in mind the losses are $101 million and $14 million has been recovered, then on the learned judge's approach, the top-down approach, then that entirely goes to Textainer because it exceeds the $85 million limit. I can explain that further if necessary, but no. That's not to assume I wasn't assuming you weren't understanding what I was saying, but just in case there was any doubt. Now, in this particular case, and in this particular case, that approach taken by the judge, I say with respect to the learned judge, was wrong, because there is this material distinction between Napier and Hunter, which was concerned with identifying a single loss at a particular date, with a situation where you have 100,000 different losses occurring at different times, in different ways, and in different kinds. So total loss, damage, cost of recovery, costs of, and loss of earnings.
Can you explain to me why you say Lord Templeman's reasoning at page 730 is driven by the date of the loss as distinct from the layers that he postulates? Because I'm struggling to see any reference in that passage to the date of the loss. It's all about the layers.
It is, but one needs to... The reason for that, my lord, if I may conjecture, because I don't know, is this, that it wasn't an issue between the parties. And it wasn't an issue between the parties because they knew exactly that they were talking about a single loss. It didn't matter when the loss occurred in the sense of what Lord Templeman does do. He, immediately before embarking upon the illustration which the parties have used to deal, which is a simple illustration to deal with what is otherwise a complex subject, Lord Templeman has just referred to the way in which the loss is to be calculated. And that, by necessity, focuses on a single date, which is the end of the 36-month period. Now, what Lord Templeman doesn't consider, because it wasn't argued and didn't need to be argued, is where you have multiple losses and how they would then to be treated as eroding each layer of cover, because it didn't arise, it didn't matter. But as of course, I've already made submissions and I'm going to continue to make submissions based on the fact that there are multiple losses eroding the cover in different ways at different times. And that's critical to an understanding how this principle will then work. Now, I would submit, if this was the issue before the House of Lords, the approach taken to considering this issue would have been very different. Of course, we'll never know, because that wasn't the issue, the problem which was the House of Lords was being asked to consider. It was put in very simple terms, based on a very, very clear statement of what constituted the insured loss. The loss as calculated by a combination of debits and credits at one point in time, which is the end of the 36-month period. So my lord is absolutely, sorry, I didn't mean to interrupt. No, my lord is absolutely correct. There's no overt discussion of it because there didn't need to be. It was understood. I'm sorry, my lord.
Yeah, so a different question is this. I understand why you emphasise the point about the end of the 36 months, but why is that not quantification as opposed to underlying liability? Because I quite understand what you're saying is it's a snapshot of the state of the account at that particular date. Quite so. But nevertheless, as I think you accepted, the state of the account is made up of a series of credits and debits, and you net them off against each other. But the fact that you're looking at it as a snapshot at a particular date doesn't detract from the nature of the underlying liability, does it?
It does. I would submit, because if
why?
If the insured sued for an indemnity at the end of the 35th month, there would be nothing recoverable.
Is that because the what is insured is the loss at the end of the 36th month? So it's not. You're saying it's not a pure question of date.
What
Point you're making?
I say it's a question of date, because that's the loss is defined as what the balance of the account is at the end of 36
but
months.
it's the balance of the account rather than on these facts the loss of an individual.
Correct. And if one goes back to page 729 of the judgment of Lord Templeman, it's page 92 of the bundle, you can see the indemnifying provision at letter B is to indemnify the assured for the amount by which the assured's overall ascertained net underwriting loss, as hereinafter defined for the underwriting years of account shown in the schedule, exceeds the amount stated as the excess. And then you have the definition, which I've already read you, which is keyed to the end of the 36-month period. So if the insured sued at the end of the 35th month, no right to indemnity, because that's not what's being insured. What is being insured is only one thing, and that's the balance of the account at the end of the 36-month period. Not the individual debits and credits, but the combination of them all. And as I said, you may not know if there's even a loss, if there's a huge injection of profits or credits the day before the end of the 36-month period.
So effectively you say distinguish Napier on the facts. The facts are very different. But why, it still leaves the question as to why to distinguish it as a matter of principle.
Because the very notion of subrogation is that if there's a recovery which relates to the loss indemnified, the insurer will benefit from that recovery. So in Napier and Hunter, the £130,000 damages recovery related to the entirety of the single loss, the net underwriting loss. In the present case, there are a large number of multiple losses. And my submission is that the Hanjin settlement, which paid 40% of the operating container losses, as a judge held, was to be prorated or applied proportionally to all of those losses. So some of those losses, on my submission, necessarily were indemnified by my clients under the primary, first, second, and third excess layers. And I appreciate this rises to the second issue, which I haven't made submissions on yet, except in part in answer to my Lord's questions. But that's not. So it's not just the facts; it's the principle. The principle of subrogation goes back to, and as it's set out in the recovery's condition, the insurer benefits from the recovery, which relates to the indemnified loss. Now, as you know, the claim is not for 100% of the recovery, at least before this court. It's for 39.3% of the recovery, because we accept that the recovery must also, on a proportionate basis, be applicable to uninsured losses. And that means it must, or at least losses not insured by the primary, first, second, and third excess policies. So that proportion must go to Textainer.
All right, have we finished with Napier?
Let me remind myself. I'm going to give you two examples. I haven't quite, if you don't mind, my lord. There are two examples. One of which is in my, and these are, I fret at examples because and you never know where they're going to lead, but I'm going to toss the coin and see how it all goes. The first example is referred to in my skeleton at paragraph 51, which is a core bundle tab 3, page 33. So the example is assuming there were 2,000 containers and 1,000 of those containers, the A containers, occurred first in time and they were indemnified under the primary policy. And then another 1,000, the B containers occurred subsequently and they were indemnified under the policy above, the first excess policy. If there was a later recovery of compensation in respect only of the A containers, so whoever was paying the compensation, it was said in terms, this relates to the A containers, not the B containers. Then there could be no dispute that those monies would belong to the primary insurers, not the first excess insurers. So that would be an instance where top-down would clearly not apply because there's been an allocation by virtue of the payment by the wrongdoer to the primary losses, not the first excess losses.
Would I be right in thinking that on your argument, the result would be the same if the losses were all sustained on exactly the same date, but nevertheless there was, to use your word, an allocation?
Yes, absolutely right.
So, in fact, this example is not driven by date, it's driven by allocation.
Yes, but the date is important for the purposes of allocation. So, I'm confusing allocation in two different senses. I think my lord's referring to the allocation by the payer of the damages.
Yes.
So that is driven by allocation. That's absolutely correct, and that's an important consideration. There is another different type of allocation, if you like, which is how do we know which 1,000 containers are to be indemnified under the primary policy or the first excess policy? And that's when the date does become important, because it's the order in which the chronological order in which the losses are sustained, which will tell you which containers are under which policies the containers are insured. So, but you're absolutely right, my lord. When it comes to allocation, has nothing to do with date. That all that matters is to which container or which loss is the recovery to be applied. If I understand my lord correctly. So that's one, but that just shows you an instance why top-down would not apply in those circumstances. On my example. Because if the top-down principle applied, even though the recovery was allocated to the A containers, it should be applied to the B containers if top-down applied. My other example is very much the same sort, but I thought it up, I may as well deliver it. Just imagine you have the world's most expensive container, which exhausts the retention, which is $5 million, a single container. Similarly, that's container A. Container B exhausts the primary limit, and the same container C exhausts the first excess layer, and so on. Now, if there's a payment in relation to container B, the primary layer, that of course goes to the underwriters of the container B, not any other layer. So the top-down principle wouldn't apply. So we say the position is no different. But the key question then becomes, what is the allocation? But that's answered by the judge. At paragraph 119.
And you're using allocation then in terms of the recovery, aren't you?
Yes, by my lord's meaning, if I may.
And that's what the judge answers with his pro rata.
He does, yes. And this is entirely consistent with the decision of the House of Lords and Thomas, which I can take my lords and my lady to if it helps. But So, now, just to make that last point good, the Hanjin settlement, other than referring to the operating lease containers, I mean, to that extent, there was an allocation. So it excluded from the settlement the finance lease containers. But what it didn't do was to identify which of the containers which were the subject of the claim. And bearing in mind, all the containers were the subject of the claim, which were lost or which costs were incurred against Hanjin. And because Hanjin had paid 40%, or agreed to pay 40% of that loss, then in the absence of any allocation in the settlement agreement, because there is none, that adopting the Thompson and Hudson approach, it's to be on a pro rata basis, as the judge found. So that gives rise to the question, my lord, Mr.
Well,
Railton,
can I just ask a question
of
about
course.
that? Yeah, it's maybe a complete red herring,
Mhm.
but that seems to suggest that the judge was wrong to adopt the pro rata approach, because the pro rata approach spreads across both operating leases and finance leases.
No, he made it clear it applied only to operating leases.
Okay, can we have a quick look at that?
Of course.
Just to remind
Well, I mean,
ourselves.
I say that very confidently. I'm pretty sure that's what he said. But let me have a look. Page,
You're likely to be right, but nevertheless, I'd like to be reminded.
yes, it's core bundle 8, page 114. And I should make it clear that the argument begins at 115 on the previous page, but I have to warn you that there was a more elaborate argument which I was adopting below. So my proportionate approach was, if you like, an alternative to another approach, which I'm not pursuing here. And from 115 onwards, the learned judge was addressing that other argument, which doesn't apply for the purposes. But it's his conclusion of paragraph 119 which matters. The Hanjin settlement was expressed to be in respect of 40% of the operating lease losses, leaving aside the question as to whether the payment discharged any of Hanjin's liabilities to Textainer, on which I make no comment. The payment was clearly, in my view, a proportionate payment in respect of those losses.
Right.
So he's clearly referring to the operating lease containers in my submission, anyway. When the learned judge goes on in the next sentence, he's addressing an argument which I'm not addressing before your lordships and my lady.
All right. Now, I'm clearly being very dense at this point.
No, you're not, my lord.
But in those circumstances, given that the recoveries have been allocated pro rata in respect of the operating lease losses and therefore nil to the finance lease losses, how do you get on your analysis into the finance lease losses in terms of subrogation?
Well, I don't, because I'm only making a claim by way of subrogation in relation to the losses which have been indemnified by my clients in relation to the operating lease containers, not this.
Right. Okay.
But that gives rise, in terms of which losses have fallen to which layer, that gives rise to issue 2, which I haven't yet addressed, my lord, on.
All right.
Because you say that it must be assumed, you asked us to infer that operating lease losses and finance lease losses were effectively incurred on a regular and
Even basis.
basis.
Correct. That would be my submission, and I will develop that later, if I may. Well, I intend to. So I'm going to move on to the next topic, if that's all right. So the next topic is, it's probably worth looking at paragraph, whilst the judgment's open, paragraphs 83 to 86, which is at page 106 of the bundle. I'm not going to read out the passages, but it will. I suspect my lords and my lady will have to read these passages, 83 to 86, when considering this appeal. But what is clear is reference to the fact that there is an aggregate limit, a reference to a preliminary claim and a final claim, and the term date of occurrence. And I just want to explain those concepts and how they, in my submission, have no impact on the analysis which I'm presenting. Now, the first point is that aggregate limits. Now, I think for this purpose, we need to go back to the policy, which is in the same bundle, at page 164. You'll see there's a total sum insured, which is a limit, $5 million, in excess of the assured's retention. But there's an annual aggregate limit, single lessees, $5 million, and an annual aggregate limit of $5 million. And the then we go to the definitions, which are at page 173. You'll see annual aggregate limit, the maximum amount the insurers will pay for any claims or series of claims occurring or with dates of occurrence during any one period of insurance.
What does that mean? Because it's singularly badly drafted.
It is. I'm afraid it is. And what it means is this. It has two functions, if I can put it that way. The first is to identify the limit of the insurer's financial responsibility under the policy. But the second is to identify to which policy year losses will accrue.
Well, that's, if I may say so, in answer to a slightly different question.
Oh, I'm sorry.
Can I put a hypothesis to you and see for your comment? If we struck out notionally the words occurring or, would it make more sense? So imagine it said, any claim or series of claims with dates of occurrence during any one annual period of insurance.
No, I think what I think the difference between the two. I mean, I think you're probably right. It may not make much difference at all. But I think what the difference is, if one looks at the definition of date of occurrence, which is on the same page. I hope you don't mind me answering in this way, my lord. But if the date of occurrence is the date of an event which may give rise to a claim recoverable hereunder. Being the first of the following to occur, and there are three events which occur. So let's just say, for the sake of argument, it's the event on the 31st of August 2000. Well, it's not just sake of argument; it's the reality. It's the 31st of August 2016, which is when Hanjin applied for insolvency relief to the Korean court. That's the date. So we know by looking at the date of occurrence, that's the date which is relevant to attach to this particular policy year, because we know it falls in the period of insurance. I suppose it could be argued generously to the draftsman of the policy that the words claims occurring it could be a claim occurring in another circumstance which is not falling within the date of occurrence. You've got three different categories. So there could be another type of claim which might arise. That's only, again, speculation. I just don't know why they've put it in that way. But what's important in my submission is that this definition of annual aggregate limit and also date of occurrence says nothing about the date on which the loss is indemnifiable and the date on which the loss occurs and the manner in which the losses erode cover, other than by fixing a limit. I'm a lawyer. I'm very conscious I may not have answered your question. I hope I have, or at least.
I think one answer maybe it doesn't matter for our purposes. It's just that we're confronted with a policy with a definition of an annual aggregate limit, which I'm struggling to make sense of. It may be that puzzlement just doesn't matter.
Well, that's my submission. Any puzzlement which exists is irrelevant for my purposes in any event. So as I said, the provision dealing with annual aggregate limit and also date of occurrence is really to identify which policy year a loss or series of, or a claim, it says, or series of claims arising, falls within the policy year. And secondly, to fix the limit. Because we know that it's a $5 million limit. The annual aggregate limit is $10 million, or if for a single lessee, it's $5 million. That's what the policy schedule says. But it's to fix the limit. And in this particular case, for a primary policy, we're working on a $5 million limit, I think. That's right.
Is that mirrored throughout the excess policies?
I beg your pardon, my lord.
Is that pattern mirrored throughout the excess policies? In other
Yes.
words, the aggregate limit is twice the single lessee limit.
Yeah, well, in this, the answer is I just don't know. But I think everyone's working. If one look goes back to the table in my skeleton, they're the limits which everyone's been working on the basis
For
of
single lessee.
for a single lessee.
It doesn't matter because we are only concerned with one lessee.
That's correct.
Yeah.
I said it was 5. I just want to make sure it is. Yes, it's 5. The limit's 5, not 10, for the purposes of our purposes. So, so then we look, and just it's what's the other point I want to bear in mind, of course, is the word annual aggregate limit refers to claims. It doesn't refer to losses. And if you look at the word claim defined on the same page, it refers to the aggregate of all losses and damages suffered by the insured resulting from each occurrence. And the word occurrence is referred to and is defined on the next page, which is basically the originating cause or source. Now, what that essentially does, firstly, it distinguishes between a claim on the one hand and a loss on the other. And it's the loss which matters. And I'll go back to the insuring provisions to make good my point here. But when we're dealing with aggregation, which is essentially what we're talking about in this context.
I'm a little puzzled because clearly you're right. Linguistically, the policy is making a distinction. But how can you have a claim in respect to something that isn't a loss?
You can, but insofar as, well, you can. The claim relates to a loss. I accept that. But my submission is, however you approach it, the definition of claim is distinguishing between is the aggregate of all losses, not just this individual loss. That's the definition of claim. So
And the relevance of that, because your case rests on looking at the losses individually.
It does, and it
Unless you're
remains-
contemplating a single claim.
But-
Or appears to be contemplating a single.
no, so it doesn't, in the sense that what the purpose of this is doing is identifying the year of account, the year of policy to which this attaches. So if you've got, let's just say, one occurrence, the originating cause, which is the 31st of August 2016 insolvency, and the losses continue for 2 years, then if they're all attributable to that occurrence, and bearing in mind as well that the end of the policy period is September. So if we're talking about, even in this case, we're talking about losses which extend into the following year. But there's no question that those following losses apply to the following year. They apply to this year because they're all attributable to the one occurrence. But it just because you have an aggregation provision, so the aggregation provision achieves identifying which policy year applies and what limit applies.
So, okay, just help me with where the definition of claim is actually used. We've got the rather difficult references in annual aggregate limit. We've just been discussing.
Yes. Well, I think it's probably, if you're content, I think it's worth going back to...
Well, presumably it must be used in the definition of aggregate limit, because if you look at the heading to the page, following expressions shall have the meaning set out below.
Yeah.
And it doesn't depend upon capitalisation.
It doesn't say that.
So although some of the terms are capitalised, not all of them are, and claim is defined, even though it's not capitalised, when we see it being used in annual aggregate limit.
And to be fair, I can't guarantee it, but I'm not aware of an instance where the word claim is used capitalised.
Yeah.
But what's important for this purpose is if one starts with the general principle, which is the loss becomes indemnifiable once it's suffered. Unless there's a provision in the policy which says that's not the case, then that must be the principle which applies. And what the definition of annual aggregate limit does not do is to say that the loss is indemnifiable at any other time than provided for by the general law. It's only concerned with limits and the policy year, nothing else. Now, if I can make that good in another way, I mean, because it's easy to, if you have a liability insurance, and I've explained how liability insurance becomes indemnifiable when there's a liability ascertained by judgment or settlement. And you often find these sorts of aggregation provisions in liability policies. So, for example, it might be the insured will insure the insured against all third-party liability or liability to third parties arising in relation to all claims arising out of an event which occurs during the policy period. The event which occurs during the policy period may be the insured's negligence in a particular way. Now, that may give rise to multiple claims by multiple persons. That single act of negligence might give rise to multiple claims by multiple persons. Now, each of those individual claims will not become indemnifiable until there's a liability established. Now, in those circumstances, one wouldn't even dream to argue that the definition of an aggregation provision which locates everything by reference to the original cause, which is the definition of occurrence in our case, affects the date on which the right to indemnity occurs. The law is that it occurs when the liability is ascertained by judgment or settlement, not before, not the date of the occurrence. It just falls to that year of account. That's all it does. Or it applies for the purposes of applying a limit or possibly an excess. So you might see that there'll be a limit of X pounds for all claims arising out of a single originating cause, or an excess of £5,000 applying to all claims arising out of a single originating cause, to avoid a limit or an excess applying individually to each individual claim. So my chief submission is that these provisions have nothing to do with ordering or reordering the general legal position as to when losses occur and when they're indemnifiable under the policy. The other point I should make, of course, is that the reference to date of final claim and date of preliminary claim don't occur anywhere else in the policy. Those terms, so you can see the definition of date of final claim 12 months after the date of the occurrence, and date of preliminary claim 6 months after the date of the occurrence. But they're not used anywhere else, and they certainly don't impact the indemnity provisions or the insuring provisions in the policy. So if we go to the insuring provisions, page 165. You'll see that the general insuring provision is that the insurers will indemnify the insured to the extent provided by this policy if equipment is lost, destroyed, or damaged whilst being moved, delivered, or repositioned, or whilst located in depots or otherwise in store. Now, just pausing there, it's worth bearing in mind that 2/3 of the claim presented by Textainer to Hanjin related to total losses of containers. It was $80 million in total out of a total of $117 million. Now, the general position, as I say, is when the loss occurs, which is when the loss becomes indemnifiable. Now, under marine insurance law, there are two types of total loss. And if I could take you to the authorities bundle, tax 60. You can see page 244. I suppose I should look at 243 first, just to make my point good. Section 56, subsection 1, a loss may be either total or partial. Subparagraph 2, a total loss may be either an actual total loss or a constructive total loss. And then if you go to the next page, section 57, where the subject matter insured is destroyed or so damaged as to cease to be a thing of the kind insured, or where the assured is irretrievably deprived thereof, there is an actual total loss. So the way the Court of Appeal has previously analysed this provision is essentially there's an actual total loss when it is physically or legally impossible to repair or recover the subject matter of the insurance. So just pausing there, to determine whether or not any of these containers were an actual total loss, it won't become an actual total loss until it is known that it is irretrievable. That's the language used in section 37, if it's an actual total loss. But it may not be an actual total loss, it may be a constructive total loss. And that's defined in section 60. Section 60 has two definitions. The House of Lords has held in the past that subparagraph 1 and subparagraph 2 are independent definitions, even though the word in particular is used at the beginning of subparagraph 2. But subparagraph 1 says there is a constructive total loss where the subject matter insured is reasonably abandoned on account of its actual total loss appearing to be unavoidable, or because it could not be preserved from becoming an actual total loss without an expenditure which would exceed its value when the expenditure had been incurred. Now, it's jolly rare, in my experience at least, for there to be CTL under subsection 1. The much more common variety of CTL, or constructive total loss, is under subparagraph 2, subparagraph 1, which says where the assured is deprived of possession of his ship or goods, which would include the container, by a peril insured against, and A, it is unlikely that he can recover the ship or goods as the case may be, or B, the cost of recovering the ship or goods as the case may be would exceed their value when recovered. Now you won't know, or one doesn't know, whether or not there is a constructive total loss on that test until it becomes at least more than, I should say, 50% unlikely. There's more than a 50% probability that possession will not be recovered. So immediately the insolvency is declared, I would say in most cases at least, it's unknown whether any of these containers were unlikely to be recovered or impossible to be recovered. So it's unlikely, you're not going to have a scenario where there's CTLs or ATLs immediately. So each container really will depend on, whether it's total loss, depends on the circumstances attaching to each container, wherever they are in the world. So as far as section 1 is, the principal cover, which is cover for loss of or damage to goods, containers, there's no reference to date of occurrence or claim or anything else for that purpose, because it doesn't qualify the indemnity obligation. It only deals with limit and the year of account. Then we come to on page 167, which is the extension. And you've got, again, the insurers will indemnify the assured to the extent provided by this policy 4, and the extent provided by this policy is referring to the limit. And then you've got 5 different categories of cost. And I think reference is made, by my learned friend at least, to, if you look at item 1, first, the costs incurred in retrieving and or repairing equipment abandoned by the lessee and outstanding repair costs and or service charges incurred by the lessee relating to equipment incurred or arising from the failure of any lessee to fulfill their obligations to the insured for such equipment and not recovered with the 183 days of the date of occurrence. So that's where the date of occurrence, I should make it clear, in this extension clause, the date of occurrence occurs in 3 locations, 3 occasions. And I want to just explain each of those references. So there, what's not clear is whether the words not recovered refers to the cost incurred or the equipment, because it's cost incurred in retrieving and or repairing. So if it's the equipment, it seems very odd that the 183 days would attach to that opening paragraph. But it might be just, for example, attaching to service charges, which is so you've got not just costs incurred in retrieving and repairing equipment abandoned by the lessee, but also outstanding repair costs and service charges incurred by the lessee relating to the equipment incurred or arising from the failure of the lessee to fulfill their obligations to the insured for such equipment and not recovered within 183 days. And it's unclear what that's referring to. But what I would say is that if you look at item 2, there is no such limitation. Item 3 refers to the date of occurrence, repair and service charges relating to the equipment raised by the assured to the lessee after the date of occurrence, which the assured are unable to collect. So these are charges which occur after the date of occurrence, but that's all it's referring to. This is post-occurrence, but creates no limitation in any sense. Then you've got 4, which is costs and expenses reasonably incurred to recover equipment, and also you have additional charges, and then you've got payments by way of ransom charges in item 5. Now, all those costs end with these words: caused by or arising from the failure of any lessee to fulfill their obligations to the assured with respect to such equipment. And then it goes on to say, including such costs incurred by any lessee and transferred to the assured as a direct result of such lessee's contractual default, bankruptcy or insolvency or going out of business and not recovered within 183 days of the date of occurrence. Now, my submission is that 183 days relates to the including the costs and expenses included, not to the overall caused by. And part of the reason for that, of course, is that makes sense, but it also fits in with the fact that only item 1 has an equivalent provision, but not items 2, 3, 4, or 5. And then you have another reference to 183 days on the next page at 168. And I also should say the date of occurrence. And that's loss of earnings. And this is uncollected rental and other charges will be indemnified under the policy. And there are 3 provisos. And the third proviso is the maximum liability of the insurers under this section shall be the lesser of 183 days equivalent charges per unit of equipment subsequent to the date of occurrence or any other limit specified herein. All that is doing is identifying a limit applicable, nothing more. And that's what exactly
the first proviso.
Such charges have been in accordance with the rates stipulated in the lease, which accrue from the date of occurrence until such time that the equipment is returned. But that just tells you the date range in which the charges are incurred. So it's the charges accruing from the date of occurrence until such time the equipment is returned. That's all it's doing.
All right.
So in those circumstances, the reference to aggregate limits, date of occurrence, and of course date of final or preliminary claim take nothing away to the general legal position as to when the indemnity arises. But of course, it is true to say that the date of occurrence is referred to, I say, but only for the purposes of identifying, for example, the date range of occurrences or the limits applicable in the extension. But what you don't see is it applicable under the primary insuring provision, which covers total losses. Now, my lords and my lady, there is therefore a decision which, one of the other factors which the learned judge below relied upon, not just a factor, a decision of Mr. Justice Langley, in a decision of Q8 Airways against Q8 Insurance, which I need to take you to, and it's essentially it's the authorities bundle tab 10. before I commence addressing my lords and my lady on this particular issue, I should make it clear that insofar as the decision is right, then we say it's materially distinguishable for a very good reason, which I'll come back to, or two good reasons. The second is that if, however, those points of distinction are regarded by the court as irrelevant, then we would say that Mr. Justice Langley's decision is wrong as a matter of principle. So this was a case, celebrated case, where which concerns the Iraqi invasion of Kuwait in August of 1990, and on the 2nd of August, when the invasion took place, the Iraqi armed forces removed from Kuwait Airport, or Kuwait City Airport, 15 aircraft belonging to the Kuwait Airways Corporation, KAC. The relevant policy provided cover up to $300 million, which was an underinsurance given that the total aircraft losses were $692 million. Then, after payment of the $300 million by the insurers, which was the limit of their obligation, KAC, the airline operator, recovered 8 of the 15 aircraft. And the issue arose whether the recovered aircraft should be applied proportionately so that the insurers would benefit from 300th of 690 seconds of the value of the aircraft, or whether or not KAC should benefit to the should be entitled to the benefit alone on the top-down principle. So that was a choice between which the court had to make. And if we could look at it's page 181 of the bundle, it's page 256 of the judgment. And this decision, I should make clear, followed a decision of Mr. Justice Ricks at the was in 1996. And the It's 181, you can see under the previous proceedings, which is Ms. Justice Langley states that the writ was issued in July of 1991. KAC claimed for the full value, $692 million of each of the 15 aircraft.
It doesn't mean that.
I'm sorry, my lord.
It doesn't mean of each. But that's irrelevant. If they had each been worth 692, the claim would be worth a great deal more. But that's
right.
That's by the by.
The claim was advanced on the basis that there were separate losses and occurrences, and thus that the maximum ground limit of $300 million did not apply. There was also a claim for spares in the sum of $85 million, or 85 million Kuwaiti dinar. KIC contended, that's the insurer, that the maximum liability under the policy was $300 million, a sum which KIC had paid or agreed to pay. And issues of quantum were directed to be tried separately from and subsequent to the other issues. And Mr. Justice Ricks gave judgment in December of 1995. And Mr. Justice Ricks held that all the aircraft and all the spares and equipment were totally lost in a single occurrence on the 2nd of August 1990 by virtue of the invasion. That decision stands and is the basis upon which the parties have put forward their cases before this court. Mr. Justice Ricks also decided that KAC was not entitled to any sum in excess of $300 million. KAC appealed against that decision, and the appeal was unsuccessful in the Court of Appeal, but successful in the House of Lords. The House decided that KAC was entitled under the policy to indemnification in respect to the value of the lost spares and equipment up to the maximum amount of $150 million in addition to the ground limit of $300 million. In the course of his judgment, Mr. Justice Ricks had also considered certain questions which had arisen on KIC's claim to be subrogated to a share of the recoveries made by KAC. In particular, between June of 1991 and August 1992, KAC recovered 8 of the 15 aircraft and some spares. As Mr. Justice Ricks put it, the scheduled value of the aircraft is $395 million. The scheduled value of the all 15 aircraft was $692 million. By coincidence, the scheduled value of the unrecovered aircraft, therefore $297 million, is almost identical to the $300 million ground limit, which has been paid out. It was in this context that Mr. Justice Ricks addressed one of the major issues, which is now before me. It was KIC's submission before Mr. Justice Ricks and before me. The credit for the value of the 8 recovered aircraft should be shared proportionally by giving 300/692 parts to insurers and 692 parts to KAC on the basis that the payment of $300 million represented in respect of each aircraft 300/692 of its insured value, and thus that when an aircraft was recovered, KAC had recovered the value of the aircraft, and so must credit insurers with the payment made in respect of that aircraft under the policy. It was KAC's submission before Mr. Justice Ricks and before me that the recovery should be allocated entirely to KAC until KAC had received a full indemnity of $300 million for the full value of the 15 aircraft lost, the so-called top-down principle. In addressing this question of the report, Mr. Justice Ricks said, in support of the top-down approach is the decision of the House of Lords in Napier and Hunter. It was there decided that an underwriter at Lloyd's who takes out a stop-loss policy to pay for losses within a band, say, excess of £25,000 up to £125,000, but loses £160,000 on his underwriting and then recovers £130,000 from a third party in respect of those losses, holds £95,000 for his stop-loss insurer. Although self-insured above £125,000, he's entitled to the first call on the recoveries in respect of the top slice of his losses, leaving the balance of £95,000 for the stop-loss insurer who insures the next slice. Lord Templeman appears to have considered the top-down approach applicable to competing claims to subrogation in the context of underinsurance or partial insurance or layers of insurance. Marine insurance was not there in issue, that's a quote. It seems to me, however, that KAC are entitled to the benefit of the top-down principle, either because it is a principle which most closely conforms to the underlying rationale of subrogation, or because any variation from that principle is confined to marine insurance. However, I make no judgment about how the application of the top-down principle will work out in practice. And I'm not proposing to read the rest because the issue, if you like, the mantle is then taken up by Justice Langley in these proceedings. And that's at page 260 or 185 of the bundle. And under the heading question 1, the aircraft by aircraft point, the context, and just Mr. Justice Langley says, following the judgment of Mr. Justice Ricks, it is no longer in dispute that all of the aircraft and all of the spares and equipment were totally lost by one occurrence on the 2nd of August 1990, nor is it or can it be contended that the top-down principle does not apply. In that connection, I should refer to the rationale of the principle as stated by Lord Templeman in Napier and Hunter, to which Mr. Justice Ricks referred to in the passage from his judgment, which I've already quoted. And then he just uses the same figures and refers to it again. And then we come back at page 186, next page. Now, the submissions, KA's submission is straightforward. The policy limit of $300 million was an aggregate limit. Insurers, in fact, paid on an aggregate basis. The analogy following Lord Templeman is insurance from the ground up to $300 million and self-insurance for $392 million, excess of $300 million. The agreed value of all the aircraft covered being $692 million. Thus, the top-down principle itself requires that recoveries be applied first to the layer, $392 million, in excess of $300 million, because the notional insurer is entitled to be the first to be subrogated, because he only agreed to pay if the $300 million did not cover the total loss. KIC's submission is that each aircraft was a separate loss, exemplified by the fact that each had its own agreed value in the policy. The premium was based on that value, and indeed on the 15 aircraft concerned, 3 were the property of the government of Kuwait, of which 1 was included in the 8 aircraft eventually recovered. Hence, it is submitted that payment made of $300 million was in effect a payment of 300th, or over 692 of the agreed value of each aircraft. Now, the conclusion. In my judgment, KAC is plainly right on this issue. I do not think there can be any justification for disaggregating recoveries when there is an aggregate limit to the limit indemnity. Moreover, the aggregate limit in the case of one occurrence applied regardless of the number of aircraft lost or whether they were the property of KAC or the government. Whether or not there were a number of losses or only one loss, there was certainly only one occurrence, is in my judgment nothing to the point. Once the top-down principle applies, I think it provides the answer as KAC submitted. Moreover, that conclusion accords with commercial good sense. Had KAC lost only 7 aircraft, which were in fact destroyed, insurers would unarguably have had to pay up the limit of the indemnity without any recovery. It would be remarkable if the policy would be so construed that because KAC lost those 7 aircraft, but also 8, or any other number of others which were later recovered intact, insurers became entitled to a credit proportion of the value of the aircraft recovered. For the same reason, I do not think the basic principle that an insured is entitled to a full indemnity for his loss, but no more, has any impact on this question, save that if KAC was not to recover the aggregate limit, I do not think it could be said to have received a full indemnity for its losses. The effective insurer's submission is that the aggregate limit of $300 million only applies in limited circumstances where there are no recoveries, but otherwise is an unpredictable figure depending on recoveries and their value. That's not what I think the policy says and means. It's also arguably inconsistent with the established principle that the cause of action for breach of contract indemnity accrues at the time of the loss. In my judgment, therefore, KAC is entitled to apply the value of the recoveries to the uninsured loss excess of the $300 million limit. So now, it's obviously in a situation which was a property insurance, which I accept, that Mr. Justice Langley applied the top-down principle. But I say there are 2 points of distinction. The first is this, that it was clear both in the judgment of Mr. Justice Ricks, but also Mr. Justice Langley, that all losses occurred at the very same moment, all on the 2nd of August.
But nevertheless, would you accept they were individual losses?
I perfectly accept that.
Yeah.
But if one adopts the approach of that it's a chronological order in which losses occur, which erodes the cover, that is a principle which doesn't apply in these circumstances.
Mm-hmm.
The second, which is important, but it touches on my third issue, which is it's not a marine insurance policy, an aviation insurance policy. And marine insurance is based very much on the principle of averaging, which I'll come back to. Now, what I would say is this, if those points of distinction, which I suggest are very real points of distinction, and as regards the first, it's important given my submissions based on when a cause of action for indemnity occurs, which Mr. Justice Langley accepts, which is the date of the loss, but it's because all the losses occurred at the same moment. That is a valid point of distinction. But if I'm wrong about that, then I'd say Mr. Justice Langley's decision is wrong, because what it doesn't do, it relies only on the aggregate limit, and that has nothing to do with anything other than defining the upper financial liability of insurers. It has nothing to do with identifying when the cause of action arises, how the losses erode the cover. And there was obviously no discussion of the issues which I'm raising before this court today in that case. In fact, the disposal of this particular aspect of the case is dealt with very shortly, and the analysis is limited. And in those circumstances, one cannot be confident that, in fact, I would say one can be confident Mr. Justice Langley's decision is wrong for the reasons I've already explored. But in a sense, this is I accept this as a wrinkle which I have to get over, but I think it's a wrinkle. It's not a very high hurdle, but it needs to be addressed.
The point that Mr. Justice Langley made about the argument, though, resulting in rendering the layer, the limit, unpredictable, applies in your case, though, doesn't it?
Well, I'm afraid that's always going to be the case with insurance policies of any sort. They are complex arrangements, particularly when you're insuring over 100,000 containers. So no, I mean, we'll look at this later, but the spreadsheet which sets out the loss in relation to each individual container is enormous. This is not a simple state of affairs. But
But it will be rendered simple by the top-down principle.
Doesn't mean it's right as a matter of principle. Simplicity is not always an answer, I would submit. I mean, the principle is, if there is a recovery, then it's subrogated to the insurer to the extent that the insurer has indemnified the loss. And if that results in a complex calculation, then so be it. But I don't think it is a complex calculation, because all that we're saying here, I mean, of course, I become tongue-tied when I try to say 300 over 692 parts. But it's much easier to say 39.3%. But once you do the calculation, it's an easy calculation. It's not hard. But simplicity is not a substitute for legal principle in this context.
Well, you have to depend on simplicity at the end of the day, don't you? You have to say, well, we don't actually look at when each of these containers was lost or damaged. We have to make some very broad assumptions on a simple basis.
That's true.
So you want to replace a a principle which removes the need to work out when the containers were lost or damaged with a simple assumption as to when they were lost or damaged.
But I would say it's not a question of replacement, it's a question of the principle not being applicable in the circumstance of this case. And legal principle is fixed, I'd say. It's set, it's clear, established by the Supreme Court and also by numerous other courts as to the way indemnity insurance works and the way subrogation works. If that, as I say, if that produces a difficult exercise, assuming it does, that's not a reason not to apply it. In the same way, if the top-down principle on a particular occasion may create a difficulty in terms of calculation, that's not a reason, if it's properly applicable, why it shouldn't apply.
But as what Mr. Justice Langley was saying is that one of the, as it were, a commercial factor in considering the appropriateness is that the effect of your argument is that although your clients have agreed to indemnify up to a particular level, in the end of the day, they will not indemnify to that level because they will take reductions based at the 39.3%.
But only because the principle of subrogation is they benefit from the recovery to the extent that that recovery is attributable to the loss they've indemnified. That's all. We're not suggesting that there should be any further recovery attributable to the insurer.
No, but again, it will mean that there will be a difference in the position dependent upon the date of payment by the insurers.
Yes, but if I may say so, I think that will be allowing the tail to wag the dog. The dog is the principle. The difficulty or simplicity of the calculation is not an answer to the principle. And I think what I'd like to say is this, that Mr. Justice Langley really gives only two reasons for his analysis. One is the fact that there's an aggregate limit, which doesn't really explain much at all in my submission. And the second is, he says it makes good commercial sense. But it's only because in those facts, in that case, it was an easier calculation to do. But I'm not sure that demonstrates the advantage of the analysis. Oh, sorry, I beg your pardon. That doesn't demonstrate the rightness of his analysis.
Well, I understand that very last submission, but why do you say the commercial good sense depends upon the ease of the calculation? Surely the commercial sense would be the same even if it was a more difficult calculation.
Well, my lord makes a very fair point, if I may say so. I mean, the commercial good sense is that if an insurer indemnifies an insured for a loss, and that insured recovers compensation from a third party in relation to that loss, then the insurer benefits from that. And that's to avoid over-indemnification. That's the principle which makes perfect commercial sense.
But does that make commercial sense where you have layers?
Yes.
And wasn't that one of the circumstances in which Justice Ricks said that
I think Lord Templeman, I think. If you're referring to page, I think it's page 182 of the bundle, left-hand column. Is that?
Yes.
Quite just under about 2/3 way down the column.
Yes, thank you. Layers of insurance.
Yes,
thank you.
But of course, what Lord Templeman was considering was the policy at hand. He wasn't considering arguments dealing with different scenarios. He was in a simple illustration concerning the particular policy at hand, nothing else. And of course, that's the breadth of the principle which is being applied in that particular case. Yes. What I would say is that the difficulty from a practical point of view, forgetting about the legal perspective, the difficulty from the perspective of the insurers in Kuwait Airways was because the losses occurred at the same time. It was very hard to know, which aeroplane the insurer was indemnifying or not indemnifying, because if it happened at different dates, then you would know that if airplane 1 was lost, that would exhaust cover up to a particular point. Airplane 2 was lost, and it would go on. And if that was the case, and if those first 8 aircraft were recovered, then you know that on my submission, that would then be attributable to the insurer's indemnity, because that's what they're paying out.
Yeah,
So-
well, I understand that submission. I mean, but on the facts, it's not necessarily true. I mean, it's a point that doesn't seem to have featured in the analysis. But he does record the fact that 3 of the aircraft were the property of the government of Kuwait, one of which was included in the 8 recovered. So at least to that extent, you did know which aircraft were which, and therefore.
In terms of the recovery, but not in terms of the initial indemnity, because I think I could be wrong, but my understanding is KAC, even though it was owned by the government of Kuwait, KAC was the insured
Yeah,
recovery.
indeed so. Yeah.
So it didn't matter. If it were 2 different claimants, I agree, that would make it much clearer which loss you're indemnifying, but 2 different insureds, but I think it was just one insured.
Yeah. Okay. So that's a red herring. Yeah.
So, but just to go back to the point of principle, though, it isn't the point being made that where you have layers of insurance, if you adopt your approach, you do effectively rewrite the layers according to subsequent recoveries, in that the overall effect differs depending upon an insurer who has agreed to indemnify up to a particular level will in fact only have paid out for at a lesser level, leaving the insured covering a higher percentage. And also it will depend upon the vagaries of whether recoveries are before or after payment, both of which are unprincipled approaches to layered insurance.
I disagree, if I may say so. If the word, I disagree for a number of reasons, and if I just take a couple. And the first, of course, is that there's no perfect symmetry between the position where you pay, where the recovery is made before the indemnity paid by the insurer and after the indemnity paid by the insurer. So if you just, because we got so many layers, it gets complicated. Just assume there are 2 layers of insurance. Forget about the retention. And let's say container 1 is lost. So in theory, a claim could be made under that policy. But before the claim is made for a payment under the policy, under the first layer, the container is either recovered or compensations received for the container. All that means is that the loss is extinguished. So that the next container which comes along then goes into the layer. So if you're just looking at pre-indemnity recoveries, the insurer's position won't be affected at all. It will still indemnify, so long as the losses go up to the limits. That won't be affected. So I don't think that would be a reason to disapply my submissions, assuming you consider them correct. As far as layered insurance is concerned, all that you're doing is all this is happening is, I mean, just take my example. It's a very bad example, I know, but the world's most expensive containers. So one container is indemnified under policy, the first layer, the second container is indemnified in the second layer, and so on. And if you know you've got a recovery in relation to that one container, there is no basis as a matter of legal principle why any other layer should benefit from that recovery other than the insurer who's paid the indemnity for the loss of that particular container. And that's the only principle I'm asking to be applied on this particular occasion. It's complicated by this sheer number of containers which have been lost, and how we consider, and of course complicated by the fact that the allocation of the settlement funds relates to one type of container, not the other. But that the principle remains true. I don't know if I've answered every aspect of your question, my lord, but they're the 2 chief responses I have.
Well, taking your example of 3 very expensive containers,
Yes.
one is covered by the primary, one is covered by the second excess, and then the insured covers the third.
Very good.
The first and the second, there's full compensation for. The insurers walk away fully made whole. The insured, who has all this insurance, ends up covering the whole loss himself.
Well, he does, because he didn't buy sufficient insurance. If he bought sufficient insurance to cover his entire exposure, he wouldn't be in that position. he's taking commercial risk. Firstly, that losses won't exceed the uppermost limit of the insurance program. But secondly, the commercial risk is that if he does make a recovery, and it's attributable to the lower levels, he's going to be he won't benefit from it. I'm afraid
That begs the question in a way, doesn't it? Because the question is, if it's top down, then he.
But the top-down principle does not get over the requirement that the recovery is attributable to the loss which is indemnified. And that's if there's one mantra which I'm going to repeat during these submissions, it's that.
Yes, well, that is a point which I think you have made loud and clear.
Well, I hope I forgive me for repeating this.
No, it bears repetition because it's absolutely at the core of your submission.
My lord, if this is a very good moment, if I may.
I think it is, yes. Very good. We'll resume at 2:00.